why don't we get started? I'll keep letting folks in as they come. Thank you again, everybody, for being here. We are here to talk about VARA rights, and we've got our attorney here, Blake Iverson. My name is Jen Krava. I'm the Director of Programming at Forecast Public Art. Just quickly, we are a nonprofit organization based on Dakota land in St. Paul, Minnesota. We were started in 1978, so 46 years ago, by artists who are interested in creating more opportunities to do art in public spaces. So we were started by artists for artists, and we still work to do that. We are a mission-driven organization, and we do three main things. One is to support artists with opportunities like this and with our grant program. We also work with folks who are looking to find artists or do planning projects or any sort of public art related or cultural planning related projects. And the third thing that we do is to create tools and share stories through our digital publication and our workshops. I am going to turn it over to Blake, who is hang on a sec. He is a partner at East Lake Legal. His practice is focused on meeting the legal needs of small and mid-sized businesses, creative professionals, and entertainers. He specializes in contracts, intellectual property, and real estate. He is a creative and strategic thinker who helps clients with both the minute details and the big picture. Blake has served twice as the chair of the Minnesota Bar Association's Sports, Arts, and Entertainment section. He's taught courses in entertainment, media law, and intellectual property at several Twin Cities colleges, and currently teaches in the music business department at Augsburg. In Blake's free time, he will be on a disc golf course, but he is also mildly obsessed with his cat named Gogo and his record collection. So Blake, thank you for being here. Turn it over to you.
Thanks, Jen. Thanks everybody for having me. I'm excited to see so many people interested in this topic. It's something that doesn't come up often enough, I'm afraid. Often, as I work with public artists on on murals and sculpture projects, and as it doesn't come up as often as it should. So glad to have the opportunity to talk to you here today. I have a pretty chill style. So if you have questions, please pop in at any time. There is, I'd like, love to have people just chime in if they want to cover something. Basically, I just want to talk a little bit about the background of, of VARA and why we have it and what it does, and then just a little bit about the kind of practical applications of it. I mean, this is not, we're not talking theory. We're talking totally practice. Want to discuss things that are relevant to your practices, relevant to the artists that you work with, and make sure that people can protect themselves. I mean, I kind of view my job as an attorney as helping artists to get paid. So that's the perspective that I come at this from. And you'll see, Jen is going to send out an email later and share it, but I dumped my little shorthand, takeaway in the chat, so you can see it there. Just a PDF document. It's a short little thing. But yeah, I'll just jump right into it. I mean, basically what we're talking about is an additional right that is an amendment to the Copyright Act, right? So copyright is the law that essentially incentivizes creators to create. It goes back, it has its roots in the English common law. And, we have, we, like the United States, adopted its own form. It's been modified several times, but it has just barely, like by this much, been modified in my lifetime. The last update was, it's the Copyright Act of 1976. So I was born in 75, squeezed in just under the wire to get a new Copyright Act, but I've been waiting a long time for an update. But U.S. copyright law is really focused on economic rights, right? It is to protect the rights of the artist. It gives copyright holders, generally the creators of things, the right to reproduce their work, to create derivative works based on an original work, to distribute and sell copies of their work, to publicly perform or publicly display their work, and then to sue anyone who has done those things without their permission. Um, the life of a copyright is the life of the artist plus 70 years. So any work you create within your lifetime, if whether you register a copyright in it or not, you have some rights. The Copyright Office encourages you to register copyrights with them because that's what and they give you the incentive of saying that that's what permits you to sue people for copyright infringement. Any questions on that? On what our law is? Okay. So I assume no one will be surprised to learn that people in the United States are not the only people in the world who create things. So every country, almost every country, let's say, has a copyright right. And it becomes an issue when they're not standardized, right? So you could, I mean, obviously in a digital age, in the age of the internet, people could infringe your work from anywhere in the world. I had an artist client whose work was infringed by somebody in Argentina several years back. One of the wildest cases I ever worked on. So anyone can take anything from, anything that's online, people can access it and infringe upon your rights as an artist. So we needed to have some sort of standardization that allowed people to enforce their rights internationally. And what the international community came up with is what's called the Berne Convention. And the Berne Convention started out all the way back in 1886. The U.S. did not join it until 1990. In addition to kind of standardizing these economic rights in copyright, the Berne Convention also gives some moral rights to artists. Basically, the right to just a few simple rights. You have the right to have your name on work, the right of attribution, the right to not have your name on work that you didn't create or that was modified, vandalized, scandalized, changed in any way that might bring you ill repute if your name was on it. And so you can claim authorship, deny false claims of authorship, and then you have the right to prevent mutilation, distortion, modification of your work if it's harmful. Now, when the U.S. came into the Berne Convention, it had to adopt, some degree of these. That last one, that right to prevent distortion, mutilation, modification, the U.S. put some pretty major caveats on that. They put some restrictions on there that basically said that you had to be able to show that your work was of a recognized stature. And then, of course, no one defined that term to be able to do it. But and this act, I mean, the United States Act is VARA, the Visual Artists' Rights Act, that was passed in 1990, and that essentially assigns or grants those rights to copyright holders in visual works. So what we call in copyright your pictorial, graphical, or sculptural works. Making sure I don't see anything else I need to answer. Okay. So it is not, this particular law doesn't cover many of the things that could be covered in copyright, doesn't cover, music, film, poetry, literature, any of that. It is just visual arts. And yeah. So any questions about that to this point?
I do.
Please go ahead.
So I'm a visual artist.
Mhm.
Does this apply? How do I say this? So usually with my public art projects,
Mhm.
I got burned really, really bad.
Mhm.
And I still would like to do something about it. Is there a statute of limitations in which you can go back to retroactively hold someone accountable for doing several illegal things with the likeness of your visual art.
How far back are we talking?
4 years, 5 years?
Yeah. So, I mean, so some of this is basically the Copyright Act has a 3-year statute of limitations to go back, on infringement. So it's 3 years from either when the infringement occurred or when and sometimes you can make an argument that it's when it was discovered. Um, and then sometimes you can make an argument under a contract claim if you had a contract for your public art, and the statute of limitations for contracts is 6 years. So, the answer is almost always the case with lawyers is it depends. But yeah, so you want to, um, it is important to to pursue your rights as soon as you know about them, because it's hard to know, like you start to get you have to get pretty clever to get around some statute of limitations claims. And just as an aside, I mean, the statutes of limitations are a defense that someone can assert if a claim is brought against them. It is not a home base that they can stand on. It's not an absolute bar, but it is a defense that is is a good one if people have let their rights lapse. But it is always worth talking to an attorney and talking about the particular facts of the case to see if there's anything that you can do.
So does it not, I don't want to dominate your time, but so does it also not make any difference whether I had a signed contract in place that said you are not allowed to use my design concept to, in this case, share it with a furniture designer, a lighting designer, a signage designer, and the architect to do several adornments on the outside of the building. So they took my design and share it with about 5 other companies to extrapolate my design without my knowledge, without my permission. It wasn't until I showed up for art installation that I realized they had the train had just left the station on several fronts.
Well, I mean, it sounds like what you might have is a breach of contract claim, which
Okay.
if you have a written contract, in Minnesota, the statute of limitations on it is 6 years on a written contract. So, I mean, I definitely recommend talking to somebody about that. Just seeing if there are, if there's something that can be done about it, and and I mean, the biggest question we'll talk a little bit more about this is, one of the challenges is showing damages.
Mhm.
It's to identify the value of your work as presented versus the value that, of what you had contracted to do. So if there's a diminishment of value, that's the measure of your damages. And sometimes that's a really difficult thing to prove.
Okay. Thank
But
you.
definitely worth looking into. Definitely worth looking into. All right. Any other questions right now? All right. Okay. So again, there's not a ton of substance to this law. It is basically just that, what happens if if somebody doesn't put your name on your work, you have that right of attribution. If somebody has taken, as Stacia just mentioned, the situation she mentioned, her work was modified in a way that was maybe not permissible. Do you have the right to have your name removed from that? Well, so under VARA, yes, you would. And then it's that issue of mutilation, modification, the right to stop that. And then if you are a famous artist, whose name we all know, if you're Andy Warhol or Jean-Michel Basquiat or someone like that, I mean, then you have this recognized stature. Your works of a recognized stature. If somebody destroyed that work either intentionally or grossly negligently, either then they'd be liable for damages for that. One thing just to back up on, just to talk for a second about, generally speaking, an artist, when an artist creates something, an artist has a copyright right in it, right? We register those copyrights to be able to enforce those rights. But you have, as soon as you put, to paint to wall, pen to paper, you have a copyright right in your work. And those rights still apply. It's just a question of registration in order to enforce them. But, even when you paint a work for, even if you put a painting on canvas and you sell that canvas, you still own the copyright in the painting. Um, you own the copyright unless and until you assign that copyright to someone else. And the purchase of the physical object of the sculpture, of the painting, of the mural on the wall, if that is your work, you own it unless and until you have assigned that right to somebody else. So, so just, a lot of people think, well, I have this client, people come to me and say, well, I sold the painting, so I don't have any copyright rights on it. And that's just not accurate. It would be very unusual to sell to sell the copyright. Great question. Just got the question. How about commission work? So it is a negotiable term in commission work. One of the things that I will, I'll, just tease it at the end here. What to do when you are contracting for something. What do you want to, is it a work for hire where it is owned by the person who is commissioning it, or do you grant them a license and retain copyright for yourself? And it's really about, that's a negotiated term. It is a thing that you should be thinking about when you're doing it. And candidly, sometimes the answer is take the money and run. If somebody wants to hire you to do something and it might not be your preferred, style or, medium or anything, and it is just a job, and then it may not bother you as an artist if you are, if you're doing something for a beer company, a brewery or somebody like that, it might not matter to you so much. And it's just a job for which you get paid, and that is the end of it, and that is fine and well and good. But if you are doing original work someplace and you would like to keep some of the other rights that we talked about, the copyright rights, the right to make derivative works specifically, that's a big one. Could you sell t-shirts, coffee mugs, calendars? Can you make things that will sell that contain your imagery, even if your imagery is on the wall of a building someplace? And that is something that you should be negotiating as part of your contract when you're creating, work for a third party. So I won't call it we can call it commissions, but we won't necessarily call it a work for hire. A work for hire is a term of art in the law that means that the person who has asked you to do this owns the work. They are the copyright owner then in a work for hire situation. And they could grant you a license back. But if you retain the copyright, then you would grant them a license to display the work. Does that make sense? Yeah. Any questions?
So I was hoping you could kind of maybe talk more about mutilation and ascension rights. I mean, I am a public artist and has worked in the city of St. Paul extensively and have often run into many calls, say MnDOT, that makes artists waive their VARA rights. And I can't tell you how many times I had to argue with attorneys to keep that. The main concern that a lot of commissioning bodies have, especially in municipal and public art things, is they're scared that they have of maintenance and what happens if they have to remove it due to public safety. And I had my rote response saying you can remove it as long as you notify the artist and all that. But I kind of I wanted a little bit more just kind of legal clarification about, if the rights are in place and you haven't waived them, because I know contractually you can, you shouldn't, but it's an option. From a municipality, let's say that a city commissions a work and they have to remove it for public safety reasons. Like, what are their responsibilities to the artist in that regards?
Yeah, I think in a public safety case, I think that the law is, it doesn't get tested a lot. Honestly, a lot of these things don't go to trial. So we just don't have a lot of case law that indicates that. But they do have upon contacting the artist, they do have a right. I mean, and this is, I mean, this comes up in the context of just degradation over time, of, things fading, of things being, damaged by, by either human action or weather or whatever. It's, I think that as an artist, you want to like be proactive at the front end. I mean, I think it's the best thing that I can say about that. Just and it's also because it's not so much about the law as it is about the practicality of it. Because again, the question is one of, you could bring a claim for violation of these rights, and the question is then what are your damages, right? So, I mean, no, I mean, the laws, is crazy expensive. I mean, candidly, like, attorneys are expensive. There's a lot of work that goes into having a trial. It's, the kind of rule of thumb is that no one litigates with less than 6 years at issue, because it's going to cost, I mean, it could easily cost $50,000 to litigate a case to, even a small case to a verdict. And so what you need to have are kind of provable damages. And, so if you have, I mean, that's, and that's what the law provides. It provides, attorney's fees and damages. But if you can't articulate a damages claim at the outset, you're not going to survive to get to a trial to prove your case. So, so this is one that I would suggest that people identify at, from the point of contracting, like what are the issues? What are the obligations that, municipality or a business owner or whoever has, in terms of maintenance, in terms of upkeep, in terms of an ongoing relationship with the artist? Because I think it is going to be tough to show those, like if you've had a work that's on display in a public place for 10 years, um, you've been paid all the money you're going to earn from it. And like you would probably need to be able to demonstrate that your, name recognition from that work, provides you a line of people who pay you, commission you regularly or something like that. You'd have to show that stuff in a pretty, like you can't get too speculative on damages. So you need to be pretty concrete about examples of how that was directly providing an economic benefit, an ongoing economic benefit to you that you've now been deprived of. If that makes sense.
Sure. No, and to be clear, my question is mainly because what happens in practice, and I get the law, in
Yeah.
practice, since municipalities are scared because they're ignorant of what they should do, they ask you to waive all rights, which loses you the copyright as well. So,
Yeah.
but I just want to be, so they, do in public safety, they, as long as there's notification and a removal of the name, they still have the rights to take it down, based on public safety, right?
Yeah, that's correct. Yeah.
Okay, that's usually my argument. I just kind of wanted, I've just encountered so many people that are terrified because of they're not sure what it encounters, that you have to waive everything, which is, then you lose copyright, which is a big deal. The other
Agreed.
ones, maybe not so much.
Yeah, I mean, I think that's, it's a frustrating thing to be a public artist. One of the challenges of being a public artist is that you are dealing with, with municipalities oftentimes, and you are dealing with city attorneys and, city councils who are by nature risk averse, and they're not experts in this subject matter. They don't, they got a budget to put a mural on something, and they don't want to think about it any further than that. And, so that's, part of my advice in this is to just, is to try and engage at the outset about, and to be realistic, but to set expectations about what happens. And so, I think that, I mean, and obviously if it's a public safety issue, that's going to trump, anything else. But to look for a term of maintenance, to make sure that a city has a budget for that, to make sure that, you are, I mean, to identify yourself to be, consulted on these things. If modification needs to be made, if artistic upkeep needs to be maintained, putting that stuff in the contract and just engaging with them about that, and trying to, have the conversation that it's not, this isn't something to be afraid of, but we should also, we as artists should set our expectations appropriately that when we have public art, it is often, it is often not permanent, in any, really meaningful sense. I mean, if we look at the history of any city, things have come and gone and buildings come and go. And, there are unfortunate things. There was the case recently in Minneapolis where a mural was painted over, and, the party that commissioned the mural was a tenant. They didn't own the building. And, that really puts, so the building owner, who was not a party to any contract, probably didn't know, any of the details about that, gets put in a position where they are now, where they have painted over something and really, harmed, the people of the city who love to see the work. So, a lot of this stuff is about communication and setting expectations and seeing if and, it's, there's that song about I fought the law and the law won. Cities are going to do what cities are going to do. And if they run into a cash crunch, the first thing that's going to go is their artistic, upkeep budget. But we as artists just need to be mindful of that when we're doing that kind of work, I'm afraid. I mean, I wish that there was a better answer and ways that we can enforce our rights, but to have clear communication, set expectation. And I think a minimum term of maintenance and upkeep is a good thing to negotiate for when you're in that position. And yeah, to your point about asking for a waiver of all rights, to waive your copyright in something is not something that should be undertaken lightly. It's crazy to think about copyrights that I mean, is anyone familiar with the song "For He's a Jolly Good Fellow"? Does anyone know why that song exists? It exists because if you tried to use Happy Birthday in a movie, the people who owned the copyright in Happy Birthday would sue your pants off. So they literally created a fake Happy Birthday song for He's a Jolly Good Fellow to use in movies and television programs. No one ever sang that song in real life. If you ever went to that, if you were at that party, please tell me, because I've never heard of it. But movies, TV, it's always there, and it's specifically for that reason. But the good news, the copyright, at long last, finally, the copyright for Happy Birthday has expired. So fire away. But it is. I bring it up, only to say that we want to be, we want to have rights and we want to enforce those rights. But to think about, the things that we do. I mean, the parts I'll tell you, I love working with artists. I love to not be able to charge artists a lot of money to work with them. So I charge companies a lot of money so I can subsidize the artists. Jen, don't send that to my clients, please. The Stevie Wonder. Well, Stevie Wonder has a different song that is, still has a copyright. So don't use that unless you want to pay Stevie. And I'm all for paying Stevie. But yes. So, and, things in the public domain anyone can use. But yeah, I mean, but anyway, I'm sorry, I'm going in 8 different directions there. But I'll back up to just reiterate, there may be work that you are happy to do for money. It's just a paid gig. You get the money and you don't worry about the copyright rights. But the more of your original artistic work that you're doing there, obviously there's something you want to fight for. And if you can think of a way to monetize it, to maintain that copyright, to get that right to create, to reserve that right to create derivative works, because if you don't, the person who the company for whom you do the work may. And that was not usually something that you negotiated for. But if something catches on, you want to be able to take advantage of that. I've had a number of clients over the years who have done prints of murals, done T-shirts, done coffee mugs, calendars, any of that stuff. sell it on your website. And I think that there's a good argument to have with, somebody who's commissioning work, wants to hire you to do some work, that what you are giving them is free advertising. That they are getting a benefit from it. So, and if they're the kind of organization that is trying to empower and engage artists, then they'll probably understand that, or often they will. Or I can write a really mean letter on your behalf, tell them they should. Any of those things. Questions? Yes, please. Oh, I think you're muted.
Oh, okay. I'm not sure if it's me. This is Peter.
Oh, okay. Well, we had Stacia going,
Okay.
and then let's start and then go to you, Peter.
Yeah, Peter, go first, because I
Okay.
already asked a question.
Okay, great. Thanks. Yeah, my question is sort of more on the commissioning side, I guess, and wanting to make sure that an artist, that it's sort of clear on both sides what the expectations are. And I think you kind of touched on this, but I just kind of want to be clear on it. And so, commissioning a mural for an indoor space, kind of with the idea that the mural won't be there forever, that it's going to be maybe a rotating thing that changes every 5 to 7 years.
Sure.
And sort of wanting to know what needs to be in a contract so that the artist understands that, and obviously the organization that's commissioning the mural knows that, so that there isn't a situation, in 5 or 7 years where the mural is painted over because a new mural is going to go there and the artist is upset. I mean, for sure, I understand that would be something that is communicated from the outset, but is there a reason to have some sort of VARA waiving of rights in the contract, or is that kind of overkill in a situation like that?
I don't think it's bad to have it in the contract. And obviously, like, okay, so this is, the thing that, this is the kind of end of this is all copyright rights, including VARA rights, are modifiable, waivable by contract. But I think, so what I would probably, whether you want to reference a law in the contract, I am all for contracts where people just state clearly what they mean. I think good contracts make for good friends. I don't put things in legalese. I don't try to make them complicated. So I may not, to answer your question, I may not reference a statute, but what I may say is, commissioning party agrees to, to maintain and this piece for a period of, 5 years, 7 years, 10 years, whatever, from the date of the agreement. And then, the question is always, well, what if they don't, right? And then, so like, again, when I'm writing a contract, I'm thinking about how are people going to screw this up, right? How are people going to hurt one another intentionally or unintentionally? And if I can take that approach to it, then I can come up, with some solutions. Well, what happens if they, if they lose their lease, if they're not the property owner, what happens then? If they go out of business, what happens then? If they decide that they'd just like to make a change sooner, what happens then? Do you get anything more for that?
Right.
If somebody wants to change the terms of the deal, can you get something additional from that? Have you agreed to, in the law, we call that liquidated damages. Basically, you pre-agree to pay, some amount of money generally, if somebody doesn't follow through on their obligations here. And if somebody goes out of business, if somebody files bankruptcy, well, you're probably out of luck. You're not going to be able to enforce that term on them in that case. So, I, like a client of mine, a local artist, did a bunch of work for a restaurant. Be careful when you work. I don't know if you've ever noticed, but restaurants come and go very quickly. And trying to get a bill paid once they've gone out of business, and they not only stiffed you, the artist, they stiff the guy who brings over the lentils and the woman who washes the tablecloths and whatever. They have probably left a lot of people in the wake, who have unpaid invoices. So your ability to collect against them is it's highly unlikely that you'll be able to. But yeah, so is there a perfect shield to protect yourself. No, there's not a perfect shield. But the more that you can anticipate ways in which things might go wrong and get the parties on the same page and agree to a course of action to pursue if they do, that's going to put you in good stead, as good a stead as you can be.
Okay, cool. That's helpful. Thank you.
Yeah. All right, Stacia, what was your question?
Okay, I'm unmuted. What, I don't know if other artists on the call have encountered this before, but I'm shocked at the number of commissioning, as a public artist, at least I do, I work with so many different commissioning bodies of different levels of savvy. And that's fine. I welcome that. And sometimes I play a much bigger role and sometimes I play a much smaller role. And that's the fluidity of, the nature of what we do, or we
Yeah.
wouldn't be doing it. But I'm shocked at the number of commissioning bodies who have said, but I paid for the artwork. Why do you still own the copyright? And I try to say, well, you own the artwork, but I maintain ownership of the copyright. And I just kind of say, well, it's like a law. Do you have a very good, like 1 or 2 sentence thing that artists can say when commissioning bodies are absolutely shocked and in disbelief and they can't get by but I paid for it. Why can't we make t-shirts and mugs and use it for our capital campaign to raise money and frame it? And so I'm just curious if you have a good response to that.
Well,
Because it kind of borderlines on the artist sort of like you have the audacity to like set a boundary. You should just be grateful you got the project.
Yeah. I mean, I think that there is a lot of that. But here's what I'll tell you. I've been an attorney for 18 years. The number of attorneys who call me who mix up copyright, trademark, don't know the difference, don't really know what either means. Those are, I took those classes in law school. I was interested in them. They were not requirements. And I would say that, I mean, like most of the people who become municipal attorneys, the city attorney for a particular, town or state, they are very into zoning laws. They have a deep knowledge of things like that, water rights, riparian rights. They know all this, stuff, but they don't know anything about the law that surrounds art. And you're right. I mean, I think that there is some condescension, like, aren't you just happy to get paid here? What I usually tell people is that, what I usually say is kind of what I said at the outset. As a creator, as an artist, you own the copyright unless and until you assign it to someone else. Yeah, there's no clear way that I've found, no shorter way to say that I can sell you my painting on this canvas and you own the canvas and I own the copyright. Unless you want to buy the copyright too, and it costs 10 times as much as the canvas. Easy enough.
Can I say one other thing? And this is
Please.
just for the artists. So we recently redid our will because our poor third child, who was born 23 years ago, was not in our will because we had not updated it for so long. Poor guy. But I realized as we were talking about assets and things like that, not that we have a lot, but I realized that in our will, I wanted to also put into our will that I own the copyright to the work in the future. In the rarest of chances, there is something that becomes monetized or profitable off of that work, that our 3 children are entitled to an equal split across all 3. So just keep in mind, artists too, like if you're in a situation where you're doing your will, it's actually good to kind of throw that out there in case, wild card of wild cards, something happens. I would just hate to cause stress among my children about anything like that, but just wanted to say that.
Yeah, no, and it's a funny thing. It's funny that you mentioned that, but because I am like, Jen mentioned all the, the various things that I do, and they're all because like I went to law school to work with creative people. And I did not go to law school to write wills. I did not go to law school to do real estate transactions. But what I found out is that creative people need wills and creative people buy real estate. So I have this like accidental practice that sprung from, most estate attorneys do not understand intellectual property. And I mentioned at the outset, but the term of copyright is the life of the artist plus 70 years. So yes, things can come in and out of vogue. And we are very lucky that we have that law now. You might have seen various, everybody knows the Edward Hopper painting Nighthawks at the Diner. Like that painting, I had to look it up for a case at one point. And at that point, the term of copyright was 26 years and it was renewable for another 26 years from creation. But it was so unimportant at the time that the copyright was not renewed and it expired. So, Edward Hopper, I believe, died young, but that, the copyright expired, many years ago. So anyone can use that, and you'll, see that it's been used in many places because it is in the public domain. Anyone can use it. All right, what do we recommend when it comes to collaborative public art? Yeah, it is. Great question. Great question. Okay, so a couple of answers. First is the copyright answer. When two people collaborate on a piece of work, or more, two or more, the term of copyright is 70 years from the date of the year of death of the last surviving artist. So this could go on a long time. Example I always use is in the years before his passing, Tony Bennett recorded songs with Lady Gaga. Lady Gaga, a lot younger than Tony Bennett. So even though Tony Bennett has now passed away, the term of copyright has not even started to run and will not run until Lady Gaga passes away. It will not start to run. So we could be talking about art rights for a long time. If you are a collaborative artist and you are working with a commissioning body, the best practice would be that the collective of artists, 2, 3, 4, whatever, have some sort of written agreement between them that identifies how they want to enforce their rights, what rights they have. Basically, what the default under the law is that let's say that the artist retained the copyright, and one of the artists, let's say there's 4 artists, and one of them decides to make T-shirts of the work and sell them. Well, they can do that without anyone else's permission. But what the law requires is that they share the profits on a percentage basis based on the ownership. So if there were 4 people, it would be presumed that they each own 25%. So I could make and sell T-shirts that I made with, of a mural that I made with 3 other artists, but my obligation under the law is to pay them each a share of that. That can be changed by contract. So I would recommend that if you are retaining rights in a work, if the artists are going to retain rights in a work, that they decide how they're going to use those rights. And it may be, I've seen it be, anyone can make any derivative works that they want, and they don't have to share their proceeds with anyone else. Fair enough, easy enough. And it may say, everyone has the rights to do it, but they have to share. And if you make something, you owe your partners an accounting. Don't do that. Don't do it. There's nothing worse than, 7 years down the line, you get an angry letter from somebody about some T-shirts you sold 4 years before. This may be the only project you ever work on with these artists, but figure it out. I usually recommend, deciding that one person will be in charge of that if they choose to do so, and that they just will have that obligation. You don't have those obligations to each other, or else that you can do everyone can do whatever they want with it, and no one owes anyone anything. But putting that on paper and signing it will save you a lot of trouble. Just, identify, what your needs are, what your wants are, and get it on paper, get an agreement in place. There's nothing worse than, we talked about it, we agreed to this. No one wants to be having that fight, sometime down the road, or for their children to be having that fight. The number of people who call me and say, well, my mother did this thing and she wanted, she had agreed to this. And I was like, okay, well, do you have a contract? No, it was, it wasn't that kind of thing. Well, sorry. It's an ugly situation, that, I don't want to deal with. Most attorneys don't want to deal with. It's so much easier if we just have a signed piece of paper to look at. Again, clear language, not taking advantage of everybody. People have negotiated this. They have agreed to it. They've signed off on it. Also, does anyone know the sign of a good negotiation? Anyone know what the hallmark of a good negotiation is? No one is happy. That's how you know you did it. So yeah, I mean, that is, that is really, the kind of long and short of it. I mean, it's, I understand what your rights are, understand how to assert those rights. You end up, to the point of this conversation, you end up kind of having to educate some people who are not thinking about you having future rights in work that they're paying you to do, that they just don't understand. And yeah, I hear that a lot from municipalities like, hey, we're paying you. Do you want the money or not? And that they don't want to hear about any of this. And, I mean, sometimes the answer is like, just take the money and just do the thing and just don't worry about it. But as an artist, I understand we worry about it, right? So, and we want to get paid for our work. We above all, artists should be paid. And if you have to have one extra phone call or two extra phone calls or go talk to the city council about it or whatever you need to do, if it's important to you, if it's a value to you. But, I would say, like, it is only important if you care and if you will assert those rights. Have the self-awareness to know you're the kind of person who will make t-shirts, who will market this stuff, who will do that part of the work, or don't negotiate for it. Don't waste your time or anyone else's time for something that doesn't matter to you. Your rights in the abstract. And of course, I mean, I say that with the caveat that we all grow up and have the opportunity to change, and we look back and wish we wouldn't have waived rights to things in the past. And, it's understandable, but, just have the awareness to really fight for the things that go to bat for the things that matter to you. In a good negotiation, again, that's kind of what falls away. Don't let the perfect be the enemy of the good.
We've got about 10 more minutes.
Yes. All right. How about public art that uses face or likeness of a person? Can they ask the artist to remove it or bring down the art? Yeah. So that is a creature of state law. In the state of Minnesota, living people have a right to their likeness. Deceased people do not in the state of Minnesota. In other states, they do, particularly states with a lot of like the entertainment industry. California, New York, Tennessee have really strong posthumous likeness rights laws. But yeah, if you are painting someone who is famous or not, if you are painting a recognizable person, you are going to want to get a release from them. And a best practice is, even if they are deceased, you probably want to do so. I dealt with a situation a couple years ago with there's a local retailer. Its logo looks kind of like I don't know, something to throw an arrow at, a dart, something like that. And they commissioned a mural, and and the last sticking point was clearing to make sure that posthumous situation, the posthumous rights, but making sure that they had an okay from, in this case, a family, from families, to make sure that they can include recognizable people in the work, that it can be displayed publicly like that. So yeah, I mean, I think it's the best practice is err on the side of caution. There is there are certain exceptions to that, for like you could, you could caricature a public figure, a politician, somebody like that if you wanted to, probably. But I think that in terms of that, in terms of making sure, I mean, here's the thing, nobody wants to get sued, right? Anyone like to get sued? Show of hands? Seeing none. Um, Getting sued is terrible. It is just a nightmare. Even if you win, you lose because it usually costs a lot of money to defend it. So I would say err on the side of caution of that. And yeah, and a living person whose likeness was displayed without their permission could definitely get, one of the remedies available to them would be to have the public work painted over. Yeah. So, like I said, California. So the question is about San Francisco. A person was murdered, became an outcry in the community. Artists got together. City funded it, but the family changed their mind. The artists still want to paint it. California has a posthumous likeness right. So if the person who controls that right and is, generally speaking, the family, that is going to, their wishes are going to trump those of the artists or the community at large. Other questions?
I guess I'm sorry, you've already touched on this. I'm just kind of re-looking through the PDF that Jen sent along. And I understand best practice. I understand things don't happen, but as somebody that's had countless hours of arguments with city attorneys, the idea is like, well, if it could, I don't care if it has happened, if it could, it, is contractual law and all that. So does a city, based on VARA rights, do they have the right to take something down? Or, it is that distortion, mutilation, and modification, and I understand it's tied to, whether the artist will follow up and do anything about it. I get that argument completely. But from a pure abstract legal sense, like can the city, if they own it, it's on their property, can they modify it? I mean, or can they just remove it? Do they have the right to take it down?
I mean, I think that I mean, the challenge is like, if there is no mention of our rights in a contract, then the question would be, is that an intentional omission or is it an accidental omission?
Let's say they do, the VAR rights are in there.
If they are in there, then they have breached the contract.
Okay.
Right? Yep. So, I mean, and then it's a question of damages, right? So,
okay, sure. I get all that, but yeah.
But yeah, and I mean, in the abstract, if the contract says that they can't do something and they do it, then yes, they would have, they would be in violation in breach of the contract.
And VAR rights do state that you can't, what I'm reading, distort, mutilate, or modify.
Yeah,
okay.
I mean,
and I
yeah.
understand like the words around it. I've always been curious about the law itself in an abstract sense.
You're the one. No, I found early in my career that I, I mean, people who become law professors are, they love, how many angels can dance on the head of a pin. They love the theoretical arguments. I try and avoid them at all costs. I mean, just because my clients don't, have the resources to fight about things. So I think, to that point, it is, I mean, like what is the better remedy? Is it just putting the letters VARA in a contract? No, it is probably being explicit about what you're agreeing to, about what rights you are retaining. And again, what, maybe a liquidated damages provision, something where you can just show up and be like, write me a check. Here's the contract that you signed. And then, you went and removed the work without, without permission.
Okay.
Yeah. Other questions? How often can an artist actually win the case? Like I said, I think it's a damages question. I think that I will tell you that the legal system in the United States, people always say like, write me a contract so I won't get sued. I tell them to move to a different country. Here in the United States, people sue people all the time for good reasons, bad reasons, and no reason at all. And it is, I'm not a litigator, so that's not, the part of the law that I practice in. So I can say that with no skin off my back, but I detest it. But I mean, so it really is just a question of like having a good contract and it being clear that there's a breach of that contract. And honestly, like if it's clear, I mean, the cases that go to trial are where things are fuzzy, right? If someone is absolutely clear and right, no one is going to spend $100,000 to defend a lawsuit they're going to lose unless they have unlimited resources and they just want to delay the process, kick the can down the road as far as they can. All right, let's first time reviewing a contract for a public art. Is there a solid website or place I can go to learn about it so it won't be so daunting? Honestly, the work that Forecast does, the work that Springboard does, they will, put you in contact with, attorneys who will work, who will work with artists at discounted rates. There are some free legal services available, depending on the circumstances. Getting, just kind of coming to, events like these. There are like I know Springboard does some stuff where they have just drop-in sessions with attorneys that are a good opportunity to to just kind of get in front of somebody who knows something. Volunteers Lawyers for the Arts is a great resource. This is I mean, the challenge of this, like I said, is most lawyers don't understand this area of the law very well. It is a specialty, and it is not the most lucrative specialty. It's the rare artist who pulls up to my office in a Maserati. So it is people who have attained this stuff because they're often artists themselves and because they have a love for the arts. But going through something like that where there are opportunities for lawyers for the arts. We're very fortunate in Minnesota to have a pretty robust system for that. Not every state is so great, but there are resources out there like that. And yes, it's an ounce of prevention is worth a pound of cure. So taking the time, and if you need to spend a little bit of money to get somebody to review something and look over something for you and make sure that you're not being taken advantage of, or they can at least tell you what the landmines are that and you've got to be comfortable with them or not to move forward. I think that is money well spent, hopefully just a small amount to do something like that. But yeah, it's it's not a perfect system, but it's the best we have.
That, I think, is a great place to end for the evening. Thank you so much, Blake, for sharing all this information. Thank you, everybody, for being here and for all of your questions. I will send an email out with the recording of this conversation as well as that PDF that was in the chat so that you have that overview of VARA, and you can come back to this and hear all of Blake's advice. Thank you again, Blake.
All right.
Thanks, everybody, for being
Thanks
here.
so much for having me. Thank you for being here.
Good night.
All right.
Bye.